Those are the two main things that we do. So what you're doing for the next 2 or 3, maybe 4 days is so important. And we appreciate you being a part of the process. We know it's very inconvenient. We all have lives going on. We know, we heard your stories today, and we know that there's a lot of conflicts, inconveniences, childcare issues, all kinds of work issues going on. So we are very sorry. We're going to try to push this along as quickly as we can. I am hoping that maybe you'll get the case by Wednesday, and maybe we'll be out of here by Thursday. We're hopeful, but we're going to do everything that we can to push it along, because we know that you guys are, you've got lives to get back to. A lot of times people want to ask, how do juries get picked? And a lot of times people think, well, the plaintiff chose me, the defendant chose me, the plaintiff chose me, the defendant chose me, all the way until you get to 12 people. That's not the way it works, okay? And sometimes jurors get mad at me when I tell them this, but it's the truth, and I didn't make up these rules. Basically, you start out with a pool of 24 people that you're trying to deal with to pick 12. And out of those 24 people, the defense gets to strike 6 of those, and we strike 6 of those. And the people that are left are you. And so I know sometimes that doesn't make you feel special because you weren't chosen, but the better way to look at it is that you weren't stricken from the jury. And that's because we have a lot of faith and credit in you, and we know that you're going to do everything that you can to pay close attention and do the right thing whenever it's time to bring back the verdict. So I'm going to be very short. This kind of getting back to what I said earlier about pushing this along. I'm not long-winded. I'm going to just take the time to introduce myself. My name is Jim Green. I live in the Johns Creek area, kind of Johns Creek, Duluth area. I've been practicing law for 37 years. Our office is at Peachtree Corners. I have 2 sons. I have one who's 27, married, and he's in law school up at Drexel in Philadelphia. And I've got another son, Carson, who's 22, and he's at Belmont up in Nashville, Tennessee. He is not married. I am married. Those are our only 2 children. And again, I've been practicing since 1988. So that kind of lets you know a little bit about me. So getting back to it, we want to thank you once again for your kind attention today. We know that this has been a trying process to try to get 12 people in the box. We are here today, obviously, because on June the 2nd, 2019, okay, that's 6 years ago, Andrea Pointer was involved in a devastating car collision, a collision that was entirely caused by the negligence of the defendant, Ms. Welkley. June 2nd, 2019 is a day that Andrea will never forget. And I just want to let you know that this case is about more than just an accident. It's about the harm that was done to Ms. Pointer, the pain, the suffering, the ongoing medical treatment she's been forced to endure because of the defendant's reckless driving. And let me step back before I go any further and just kind of let you know, the defendant is a very, very nice person. We expect during the course of the trial that you're going to get to hear from her. She's very pleasant, and my client doesn't bear any ill will towards her at all. We're not going to be here to show that she maliciously caused this accident. She didn't. And we don't have to prove that she meant to cause the accident to be able to recover. All we need to do is just show that she had a momentary lapse in judgment. She was negligent for a period of a very few seconds. That's all that we have to prove. And again, I'm not going to, I've been practicing law for too long. I don't like making enemies. I like making friends. So you're not going to hear me yelling at the defendant. You're not going to hear me get upset with her. You're not going to hear my client do any of that. Like I said, she's a perfectly nice person. And we all wish that we didn't have to be here today. But the reason we are here today is to ensure that Ms. Pointer receives the justice that she deserves, because what happened to her that day was preventable. Defendant's actions or careless actions and her disregard for safety led to the collision. So I want to begin about talking about what happened on that day. Again, this collision happened on June the 2nd, 2019. Andrea was a passenger in a car being driven by a person by the name of Adam Lane. You're gonna hear him testify later. Andrea and Adam were boyfriend girlfriend at the time. They have since broken up, but they've remained friends over the years. And you'll hear them testify about that. But basically, on that day, Adam was driving. Andrea was a passenger in the passenger seat, front seat. They were taking their dog home from the kennel. They had been on a trip. They had gone to pick up the dog. They were taking the dog home. When the accident occurred, as you can probably guess, Andrea had her feet up on the dashboard. That's where all those questions came from about the feet on the dashboard. Feet were on the dashboard, seatbelt on. Adam was wearing his seatbelt. They're proceeding straight through a green light. They have the right of way, green light, straight through. And at that point, Miss Welkley turned left in front of them and caused this collision to occur, basically. So again, a momentary lapse. If my client had spent a little bit more time at the kennel that day, or a little less time at the kennel that day, the accident wouldn't have happened, because again, it's a matter of seconds. She was just in the wrong place at the wrong time when Miss Welkley turned left in front of her. So obviously this caused a major collision, and the front of the defendant's car hit the side of Mr. Lang's and Miss Pointer's vehicle, and the crash ensued. Andrea's life was upended. It was a terrible collision. You're going to see pictures of the property damage, and you're going to wonder how anybody ever made it out of there alive. I mean, it was a serious, serious collision. So we anticipate that the witnesses that you're going to hear from, first is a police officer. His name is Officer Moravec. He's with the Forsyth County Sheriff's Office. He's a corporal now. He wasn't at the time. He was an investigator. And we believe that he's going to testify. And by the way, the people that I'm telling you are going to testify, we hope, in the best of all worlds, are going to be here to testify. But don't hold it against me if I tell you about somebody that might be here to testify and then they're not able to show up for one reason or the other. So what I'm going to be telling you is what I expect to happen. So basically what I think you're going to hear from the officer, Officer Moravec, is that the crash wasn't caused by any outside factor. There were no road hazards, weather conditions, or anything else that could have contributed to the accident. The fault of this accident was simply the fact that Miss Welkley turned left, failed to yield the right of way to the vehicle my client was a passenger in. That's the only thing that you're going to hear with regard to what caused the accident. Now, the people who are going to testify, Andrea is obviously going to testify, and you're going to hear her talk about how the accident occurred, and more importantly, what her injuries were, what the extent of her injuries were, and what the future of her injuries look like they're going to be. You're going to hear from the driver himself, Mr. Lang, who was, again, her boyfriend at the time. And he's going to testify about how the accident happened. And he's going to testify about how Miss Welkley pulled in front of him, that he didn't have enough time to stop, nothing that he could have done to avoid the accident. And he's also going to testify because, again, they were very, very close at the time. So he's also going to be able to testify about her injuries and about what her life was like before the accident occurred and after the accident occurred. You also, and again, Officer Moravec is going to testify about what his investigation of the accident scene was. You're going to hear from an independent witness, I believe. His name is Ted Whitehead. And Mr. Whitehead is going to testify about his, he was what we call an independent eyewitness to the accident. And he was behind and to the side of Miss Welkley's vehicle when she turned left. So we expect the evidence to show that he's going to testify that, again, she made the left turn in front of him. Now, at this point, I anticipate that Mr. Whitehead is going to testify that he thinks that my client's boyfriend, Adam, may have been speeding or may have been going fast. I don't think he's going to say he was speeding. I think he's going to say he thinks he was going fast when the accident happened. But he's also going to testify that if not for the left-hand turn, that the accident never would have happened. We think that you're going to hear more testimony that our client was not speeding. He was going the speed limit. They were in a hurry to go nowhere. They were headed home. There was no reason for them to be going fast at all. And again, Andrea was a passenger in the vehicle. She wasn't the driver of the vehicle. So obviously she wasn't pressing the accelerator down when the accident occurred. So we believe that you're going to hear from even Ms. Welkley is not going to be able to say that how fast our client's vehicle was going whenever this accident occurred. So we plan during this trial to show you all the emotional toll that is taken on Miss Pointer and the life changes that she's made as a result of this. Her pain and suffering have not only affected her physically, but also emotionally and financially. The effects of the accident are long-lasting. Her ability to work, to take care of herself, to enjoy life have all been dramatically changed, all because of the actions of the defendant. This case isn't just about physical injuries. It's about those injuries. It's about what those injuries have done to Miss Pointer's life. We ask of you, the jurors, to hold defendant accountable for the pain that she has caused. And the law requires that when someone acts carelessly, they must pay for the harm they cause. That's just the way that Georgia law, and that's the way most states' law is written. If we make a mistake, if we have a momentary lapse of judgment, and we cause somebody harm, we have to pay them. It's compensatory damages, and it's the law that the judge is going to read to you. So again, and that's when we were talking with a lot of the jurors earlier about holding their biases aside. We want you to just listen to what happens in that witness chair here, and then apply that to what Judge McAfee tells you at the end of the case. You're the trier of fact, as he said. He's the trier of law. And at the end of the case, he's going to give you the law to apply to your facts, and then you're going to be the ones that go back into the jury room to make the decision. So in conclusion, we expect the evidence to show that the defendant was liable for this collision. We're also going to show that Ms. Pointer's life has never been the same since this accident occurred. We're here because Ms. Pointer deserves justice, and the defendant needs to be held responsible for the harm that has been caused. Over the course of this trial, we will show you how the evidence supports our claim that the defendant was negligent. We will also show you how these actions directly impacted Ms. Pointer's health, her well-being, and her future. We also expect the evidence will show that Andrea's medical bills are north, far north of $90,000, and we're going to itemize those for you. But this is not a whiplash type injury. It's, she treated with a chiropractor, but it's not just a chiropractic case. She had major injuries from this, and you don't accumulate $97,000 in medical bills, obviously, unless you're hurt very badly. So at the end of the trial, we're going to ask for a fair verdict, the verdict that will compensate Ms. Pointer for her pain, her suffering, her medical bills, lost opportunities, shock, anxiety, everything that she's been through. Justice is what she deserves, and that is what we will seek for her on her behalf. So thank you, Your Honor, and thank you, ladies and gentlemen of the jury, and I look forward to continuing this process. Thank you.
Does the defense elect to make an opening statement this time? All right. Mr. Ma, you can proceed when ready.
Hi, my name is Jonathan Mock. I'm an attorney over at Fay Major in Brennan, and we represent the defendant. And I would like to echo some of the same sentiments that the plaintiff's counsel made at the beginning in regards to your service on the jury. It is greatly appreciated, and we would not be able to have a trial without your participation and your service. So we have heard how the plaintiff plans to portray their account of the accident, but just like a coin, every story has two sides. This opening statement is not considered evidence, but this is my opportunity to show you what I feel the evidence will show. The evidence will be testimony from the plaintiff, the defendant, the plaintiff's driver, Adam Lang, the witness, Walter Whitehead or Ted Whitehead, the investigating officer, Vincent Morvac, the plaintiff's medical expert, Kirsten Willett, and the defendant's medical expert, Neil Negrin. Also, medical records will be admitted into evidence for your review. The testimony the plaintiff will present will be that she worked as a dental hygienist and realtor, and that she was a passenger in a vehicle that struck another vehicle as it was making a left turn, and that vehicle was driven by the defendant and at fault for the accident. The testimony the defendant will present is that she made a left turn with no oncoming traffic within approximately 100 yards of her, but the defendant's driver decided to speed up to catch a yellow light and did not use the lane to his left to avoid her and struck her vehicle. The plaintiff's driver, Adam Lang, will corroborate the plaintiff's account of the accident, but he himself has an interest in the outcome of this lawsuit because he has filed his own lawsuit against my client for the same accident. The testimony of the witness, Walter Whitehead, will be that he observed the accident occur in front of him, but he did not have a view of the traffic light color for either the plaintiff or the defendant because he was facing across the highway that the plaintiff and defendant were traveling along. The testimony the investigating officer will present will be that he did not observe the accident occur firsthand, but he arrived at the scene afterwards, and his investigation entailed obtaining statements from individuals who were involved in the accident and observing the property damage afterwards. The testimony of the plaintiff's medical expert, Kirsten Willett, will show that she first evaluated the plaintiff in June 2023, which was 4 years after the accident occurred, and when litigation was already well underway. The testimony of the defendant's medical expert, Neil Negrin, will present will be that the medical records show evidence of minor contusions of chest, abdomen, right elbow, and right knee pain of the plaintiff following the accident, and no evidence of any hip injury, neck injury, back injury, or any other musculoskeletal injury was observed. He will show that 3 to 4 weeks of chiropractic and physical therapy treatment was reasonable following the accident, but no further treatment or testing after June 20th, 2019 was related to or necessitated by the accident on June 2nd, 2019. For the purposes of this trial, my client is taking responsibility for the accident, but we want you to hear evidence that will show my client was not entirely at fault for the accident. During the litigation of this lawsuit, my client never admitted to accepting full fault for this accident, but did say she contributed to it. The evidence will show that my client, Ms. Welkley, grew up in the area where the accident took place and made that left turn where the accident occurred dozens of times before. She has never been in another accident except for the one we are here for today, and another where she was bumped into from behind and not at fault. On June 2nd, 2019, my client was coming from her childhood home and on her way to her summer job. My client was getting ready to make a left turn and the light had just turned yellow. My client knew that the light would soon turn red and she didn't want to be caught in the middle of the intersection, so she looked to see if there was any oncoming traffic to proceed to make her left turn. She saw a vehicle that was approximately 100 yards away before the entrance to the SunTrust Bank on that at that intersection, and she proceeded to make her left turn. To her surprise, the vehicle that was oncoming decided not to slow down and speed up to catch a yellow light that was approximately 100 yards away. At that point, she had enough time to react to try and speed out of the way of the other vehicle, but she was still struck nonetheless. So you may consider whether the actions of other individuals contributed to this accident and whether that may act as a reduction of liability towards my client. The judge will charge you that the plaintiff must prove by a preponderance of the evidence that my client is liable for the accident and the injuries she claims to have suffered were caused by this accident and not caused by any previous accident, event, or condition. Now, I want you to remember this phrase, RRN, reasonable, related, and necessary. You will hear testimony that the plaintiff refused any medical treatment at the scene of the accident and reported to the Northside Forsyth Emergency Department on her own later that day. There she was evaluated with physical examination and x-rays of the chest, right elbow, and right knee. No fractures or abnormalities were found. More importantly, the plaintiff herself did not complain of any back pain following the accident, and the emergency room doctor did not order any x-rays of her spine. This is significant because the plaintiff was a 64-year-old woman at the time of the accident with pre-existing cervical and lumbar degenerative arthritis, and immediate pain would be expected if an injury occurred to someone with those conditions. She followed up treatment with her primary care physician, and CT scan showed no post-traumatic injury. In fact, the evidence showed that she suffered minor bruising without significant swelling due to the airbag, shoulder belt, and lap belt, but she did not report any hip pain, other musculoskeletal joint pain, muscle weakness, headaches, or dizziness 3 days after the accident. She treated next with a chiropractor on June 20th, 2019. The evidence will show only complaints of pain and within a reasonable degree of certainty, no injury to the cervical or lumbar spine caused by the accident. 3 to 4 weeks of chiropractic and physical therapy treatment was reasonable following the accident, but no further treatment or testing after June 20th, 2019 was related to or necessitated by the accident on June 2nd, 2019. After June 20th, 2019, when the plaintiff reached her maximum medical improvement, you will hear testimony and see medical records that she continues to seek medical treatment for the remainder of 2019, throughout 2020, throughout 2021, throughout 2022, throughout 2023, and throughout 2024, which is more than 5 years after the accident. After June 20th, 2019, the plaintiff continued to seek medical treatment with a chiropractor and her physical care physician. On August 7th, 2019, x-rays of the cervical spine were performed and compared to a prior November 18th, 2013 exam taken almost 6 years ago. This comparison showed chronic degenerative conditions that had not changed since November 2013. The plaintiff complained of neck pain and bilateral shoulder pain on September 18th, 2019, which was several months after the accident. And these were her first complaints of shoulder pain. She received injections for shoulder pain on October 30th, and October 16th, and December 11th of 2019. And once again, there's no evidence in the medical record to suggest an injury to either right or left shoulder occurred at the time of the accident, and this treatment was unnecessary and unrelated. She continued to treat into 2020, a year after the accident, where she complained of neck pain, particularly after work as a dental hygienist and working on the computer. Treatment in June and July of 2020 noted that she complained of her hip after playing golf and her mid-back was sore after working out. On August 18th, 2020, an MRI scan of the cervical spine was performed again that showed once more no evidence of acute bone, soft tissue, or disc abnormality, and no evidence of nerve root impingement. The MRI did show evidence of chronic degenerative cervical conditions related to long-standing pre-existing conditions unrelated to the accident on June 2nd, 2019. In 2021, she complained again of neck pain from working at a computer, and in 2022, she continued to complain of neck pain. In 2023, more than 4 years after the accident, she complained of neck pain and low back pain radiating down the left leg, which was the first complaint to be made, which was more than 4 years after the accident. She also complained of hip pain at that time and received an injection at the top and outside of her hip bone on June 22nd, 2023, which was also more than 4 years after the accident occurred. The plaintiff continued to treat into 2024 and concluded treatment on September 5th, 2024, which is more than 5 years after the accident occurred. The evidence will show within a reasonable degree of medical certainty that none of the treatment the plaintiff received from any provider in 2020, 2021, 2022, 2023, and 2024 was related to the accident on June 2nd, 2019. For years after the accident, the plaintiff complained of back pain, right hip pain, concussion, cervical ligament sprains, shoulder pain, and now a ruptured left breast implant that was allegedly caused by the accident. However, there is only evidence of minor contusions to the chest, abdomen, right elbow, and right knee following the accident, and no evidence of any hip injury, neck injury, back injury, or any other musculoskeletal injury. There is also no evidence of a new breast implant rupture in the medical records after the accident. There were prior ruptures in 2015, 2016, 2017, and 2018, but none afterwards. In 2013, the plaintiff was already complaining of neck pain and degenerative arthritis in the cervical spine. However, at the time of the accident and the days following, the plaintiff never complained of back pain and only some neck pain. That examination revealed no specific injury and no evidence of neurologic abnormalities. The question you will have to ask yourselves is whether all of this treatment after June 20th, 2019, or even until 3 months after the accident, was reasonable, related, and necessary, and the evidence will show it is not. Here, the plaintiff is claiming medical treatment over the span of more than 5 years as related to this accident where she refused medical treatment at the scene and chose not to take an ambulance to the hospital. Take that for what you will. In closing, the judge will charge you to assess whether my client was at fault in this accident and whether the accident caused the extent of the damages the plaintiff is claiming. Remember, only medical treatment that is reasonable, related, and necessary will fulfill the plaintiff's burden of proof for her to prevail, and evidence will show that any treatment after June 20th, 2019, or even until 3 months after the accident, being August 2019, is not related to the accident, and the extent of her damages ends there. This concludes the opening statement of the defense, and once again, thank you for your time.
All right, thank you, counsel. All right, members of the jury, at this point, we've covered a lot of ground today. Thank you again for your time. We will be back ready to go at 9 o'clock. And unless there are any concerns we need to bring up from anyone else or any other questions, we'll see you then. Please don't discuss the case with anyone or do any research while you are away. See you back tomorrow morning. Thank you.
All right, Jared.
All right, thank you, everybody. Anything to take up on the part of the plaintiff before we adjourn for today?
Not on behalf of the plaintiff, Your Honor.
All right, anything on behalf of the defense? Okay, let's show up a minute or two before 9, just so I can summarize some of the things we want to have on the record that we've talked about, and we'll go from there. Thank you all.
Thank you.
How long does it take before they usually let them out? Because I like to stay behind and not ride elevators down and stuff.
I mean, the elevators around here, I couldn't tell you. They'll probably be
15, 20
running,
minutes?
screaming for the door. I mean, I would say you give them 5, they'll probably be out of here.
Okay,
But I
thanks, Your
appreciate
Honor.
the sentiment.
Yeah, all of them. We're not allowed to have on camera.
Right, and again, we need to collect those jury packets.
I've got them right here.